Hey guys, welcome back to another video. Today we're going to be talking about M&A lawyers in the buy-sell process and really focusing in on what do M&A lawyers do, what are their costs, what are some of the common mistakes to avoid, and what are some of the best practices to keep your costs down as you're going through the process. And this video is both for business buyers and also business sellers. I hope more business sellers listen to this because definitely I have a lot of clients and prospects that I come across that will benefit from this video. So just as a quick background for myself, I'm a Canadian investment banker focused on the lower middle market. So I primarily sell businesses in that $2 to $50 million enterprise value range. We sell about 15 companies a year. We're quite busy and we come across a lot of different M&A lawyers throughout our transactions, some really good and also some really bad that create a lot of problems. So the reason why I wanted to put this video together is to walk through a complete picture of what the value of a good M&A lawyer can bring to a transaction, and what are some common mistakes that we see when business owners approach the decision to hire a lawyer. So let's jump into it. So an M&A lawyer is a critical member of the team for both the buyer and the seller, and you can't get a deal done without a lawyer at the table. And the reality is that the right legal partner must have the relevant experience that in terms of both M&A law, but also working with the size of business that you are working in, as well as the industry that you're in. The more relevant their experience to your specific size and industry, the better and smoother that closing process is going to go. They must also have the capacity to work with you and a good chemistry fit in terms of communication style and negotiation style for both you as the client that they're representing, but also for the counterparty, be it the buyer or the seller on the other side of the table. Because if that buyer or seller may be less sophisticated and you have a lawyer that's very aggressive and really kind of too slick, that can actually ruffle feathers and create problems in the process. So we'll get into that. But I'll start off by saying, what is the most common legal issue that we see in M&A transactions? For me, it's a business seller that picks a lawyer that they've been working with for over 20 years, have a really good relationship, that have helped them with their business issues over the years, and they choose that general corporate lawyer to help them with their M&A transaction. And the reality is they may be really good at just the general corporate law and understanding business law, but M&A lawyers are specialists. No different than going to a medical practitioner. If you have a brain issue, you wouldn't go to a general practitioner, you'd go to a brain surgeon. And it's no different here. M&A is a very specific trade within law, and it requires staying up to date on market terms, on different areas and issues that arise in the M&A market. And so if you don't hire a specialist, that can actually penalize you greatly. And we see that very often in our transactions where family-owned businesses have long-time relationships with a lawyer or two, and they choose to work with those lawyers because those lawyers are not going to say no to that work. M&A work is very attractive, it's sexy, it's a lot more profitable for lawyers as well. And so there are a lot of lawyers that will say yes to a deal when in reality they're probably not the most equipped and most skilled in that area. And the challenge is when you hire the wrong lawyer, what that does is it exposes you to legal risks because they may not understand the market terms. It adds a lot of stress throughout the deal process for everyone involved, including us, but especially the buyer and the seller that are trying to negotiate and also have a relationship after that deal closes. And then as well, it results in a longer closing process, which ultimately drives up the fees for everyone in the process and makes everyone lose out. An efficient, capable M&A lawyer keeps the fees lower, moves the process along very quickly, and just gets the deal done. Okay? So let's start off by looking at what do M&A lawyers actually do. There are several key documents and milestones in a transaction where the lawyer is really leading that process and key to that process. The first one is the letter of intent. That is really that final documented offer that a seller signs back and commits to that specific buyer to go exclusive with. And that document can be 2-3 pages, or what we recommend is it should be a little bit longer, maybe 7, 8, 9 pages, and really fully fleshed out in terms of details. And the more details in an offer, the more likely an M&A lawyer is going to have an opinion on that offer. And you want to make sure that you as a seller are running that offer by a lawyer before you sign any offer. And no different for the buyer, you should have a template that is vetted by an M&A lawyer so you make sure that your terms are up to date as well and protected from your side as well. Now, the primary function that they do is also they lead and complete the legal due diligence process once an offer is signed. They're running the searches to make sure if there's any liens on the business, if there's any outstanding lawsuits. They're confirming what the legal tax structure is as well to make sure that both the seller and the buyer are structured in the right way to pay the lowest amount of tax. And then the primary documents in a transaction, there's really three key documents. The first is the purchase and sale agreement. That's really the document that is the 90-page version of a letter of intent. It goes into a lot of detail on different representations and warranties, which are really the promises that a seller makes about the quality of their business and the status of their business. In addition to the purchase and sale agreement, there's an appendix, which is really the disclosure schedules. And so those are the supporting information required to back up the reps and warranties in the purchase and sale agreement. And so really that's one document, but it's separated into two key steps. There's the wording within the purchase and sale agreement, but then there's also the content within the disclosure schedules that needs to be fulfilled by the seller and then, consolidated and organized by the lawyer into the disclosure schedules. So that's the first document, the purchase and sale and disclosure document. The second one, if relevant, is a shareholder agreement. So say, for example, you sell 100% of your business. Well, you're not going to be a shareholder moving on. So there's not going to be a shareholder agreement in your closing process. But say, for example, you sell 90% of your business and you hold back 10%. Well, then you're a 10% holder moving on. And therefore, you need to have a shareholder agreement to protect you with your new partners that have just bought 90% of your business. So that shareholder agreement has a lot of terms around certain protections and clauses and what decisions can be made with the 90% partner only versus everyone has to agree, and it therefore is 100% consent. So that is another document that the lawyer will lead. And then the third document is usually anything to do with real estate. Whether you own the real estate or you're leasing the real estate from a landlord, there will be a real estate lease and or real estate purchase document if you choose to buy the real estate as well. And so that lawyer, sometimes they'll do that themselves, or if you're working with a bigger law firm, the M&A lawyer will actually bring in a real estate specialist lawyer who will then lead that function and complete those documents. So really, there's the purchase and sale agreement, the shareholder agreement, and anything related to the real estate, be it a lease and or purchase and sale agreement for the real estate. And then lastly, one of the other key things that they do is they get involved on the seller financing. And so most SME transactions have some sort of seller financing, be it a loan between the seller and the buyer, an earnout but contingent on future performance, or again, it could be stock. But with seller financing, there has to be underlying security for the seller to be protected against the buyer just walking away with the business and never paying them. So usually there's a general security agreement, and there's additional share pledges and or personal guarantees that the buyer has to sign and provide the necessary security for the seller to extend that seller financing. So a competent lawyer, and this is where if you're not really a strong M&A lawyer, you may actually miss certain security provisions in place to protect the seller from having the right protections in place for seller financing. So that's where I see a couple of gaps where we have to flag those risks for our client as well. And then as well, if there's bank financing involved, and the lawyers on the buyer side will negotiate with the banks to ensure that the banks have their security in place to fund the transaction, and also make sure that from the buyer point of view that they're protected in terms of the outlines of those agreements with the banks. So that's what a lawyer does. A lot of the times where they get involved with is just before an offer is signed, where the terms are flushed out, the business side of the negotiation has been addressed, and now you're trying to paper that business discussion, as well as now create the legal structure and the rules and protections from both parties so that there's a clear rule book in place to manage that transaction and closing. Okay? So when do lawyers get involved? So, for the seller, we always recommend that you interview at least 3 law firms before you pick your M&A lawyer. You should have a good understanding of the marketplace. You should get multiple quotes to understand what pricing looks like in the marketplace. And the best way to find a lawyer is actually to ask for referrals from other people that are around you, be it your accountant, your investment banking advisor, or your commercial banker. But really, those people that are already working on other M&A transactions because they have other clients that have gone through this process probably have a good network of M&A lawyers that they can refer you to. If you ask your buddy for a reference, that's great, but maybe your buddy actually also used someone that probably is not strong. So to mitigate that risk, we always recommend that you reach out to contacts that are in the M&A space that can vouch for the quality and specificity of the M&A skilled contacts. That's very important. And it's important to also not only interview the same type of firm. So don't go to all the national big major players. Interview one of the larger firms, but also try a smaller firm to get a feel for what is a better fit for you, because for everyone it's going to be a bit different. And we'll talk about this in the next slide where, for one client, they may really like the comfort of the brand of a bigger firm, whereas another client may like the nimbleness and the personal relationship of working with a smaller boutique law firm. So it's important to get both. Now, in terms of timing, for business buyers, you ideally want to find your M&A lawyer before you find your target company. So that's as you're starting your search, you should also be interviewing not only the business broker community and the lender community, but you should at least have one or two M&A contacts that you can bounce off ideas off of. And especially there's a couple of lawyers that are specifically geared towards serving the business buyer community and especially the search fund ETA type investor. And they recognize that the value add that they can bring early on in the process is maybe actually giving you some freebies, some free advice. Maybe they'll take 30 minutes of your time. You'll walk them through a deal that you're looking at right now and some that involves some sort of legal risk. And they may just be able to give you that kind of free advice just so that they can build their brand in front of you so that when the time does come for you to close on a deal, you'll pick them because obviously they added value to you. So there's a lot of those lawyers actually out there that are geared towards the business buyer community that are willing to give you that type of free short-term advice. And you should know those people before you find your target company. Because really one of the key things that we recommend every buyer do is you should invest in a standard LOI template. And so you can go obviously online and download those templates that you are available for free. We also have some that are more detailed. Like for example, on my website, we actually have a vetted LOI template that is used by Canadian business buyers. And so you can buy that as well. But even if you get that template, I still recommend that for your specific, state and or province and situation, you should make sure that you get that vetted and checked by a lawyer so that you're not missing anything specifically in your situation. And then the added benefit of having a qualified M&A lawyer is that they could also be a referral source of investor capital, which is a big need for a lot of business buyers that maybe are looking to raise capital. Oftentimes, these M&A lawyers are seeing a lot of transactions, are connected to high net worth investors, and they may actually be a connector for you and help you in raising capital for your deal. So don't neglect building that relationship earlier on, because if you just get involved at the LOI stage and they don't know you from a hole in the wall, yeah, you're a client to them and you're paying them, but you haven't really built a deep enough relationship to potentially lean on them to be a source of capital. So that's an added benefit of meeting them earlier on in the process. Now, flipping the discussion more to the business seller side, the reality is there's two types of lawyers that get involved from the business seller side. There's the tax lawyer, which we always recommend you get involved at least 2 years in advance to make sure that that tax-focused lawyer understands your family structure, understands the holding and ownership structure, so that you're structured in the most tax-efficient way to pay the lowest tax bill for your sale. But the M&A lawyer, you don't really need to get involved with them until you actually have an offer. Because for M&A lawyers on the sell side, really their work starts to kick in once the business negotiation has happened and terms are starting to be papered. At that point in the process, once a document is in front of you as a seller, that's when you get really, really close to signing. Make sure the lawyer reviews the document before you sign any offer so that any terms that may be missed or get addressed now. Because the challenge is if you bring him in too late in the process and you've already signed the document and then the lawyer says, wait, what about this? And you're like, yeah, that's right. Let me put that back in. Well, now when you change a signed document, that creates a lot of mistrust and creates stress in your relationship with the buyer because you're technically reopening the deal because you've already signed the offer. So don't do that. Just have the conversation with the lawyer before signing back your offer. Okay? So, big question for most people is big versus small, okay? And it's no different than picking your accounting firm. Same thing with law firms. the reality is there's no right answer. It's not like you can say, oh, you're always going to be safe with big firms, because there are certain deals where it doesn't make sense to go with a big firm. Like, I'll just talk to you about a really specific situation. Yesterday, I met with a buyer. He's looking at buying this $2 million, business. And so we're talking, and I ask, I'm like, oh, do you have an M&A lawyer? It's like, yeah, like I'm using Stikeman Elliott, which is a very big firm. And I kind of want to scratch my head thinking, like, why would you use Stikeman Elliott for a small $2 million deal? Like, that's, Stikeman is going to cost you at least $75,000, which is very high for a small deal. So sometimes the size of your deal is going to influence the size of the firm that you're going to work with. The smaller your deal, if you're doing a $2 million transaction, you should go with a smaller firm. Now, the reality is, as you're going bigger, it doesn't mean that you have to go with a bigger firm as well. So, if you're working on a $10 million deal or a $20 million deal, I've seen 1-2 partner law firms handle those deals effectively, but it just depends on the situation. And so here are some parameters to think about. The biggest one is complexity. The more complex the transaction, so if there's an equity raise, if there's cross-border, so maybe it's a U.S. company buying a Canadian company, or a Canadian company buying a European-based entity, if there's any special tax situation, be it industry specific, maybe it's indigenous owned, First Nation owned, maybe there's a union agreement and there's a collective bargaining agreement that needs to be transitioned, or maybe there's special government approvals, right? It's a defense contractor company and there are different approvals in place. The more complex the deal, the deeper your bench knowledge needs to be in terms of that law firm being able to give you that full service experience, so that you don't end up in a situation where you pick a smaller firm that maybe doesn't have that experience, that issue comes up, and that law firm has to go to another law firm to sub out that work, because that just creates more cost, slows down the deal for you, and ultimately now you feel like, well, your lawyer's not doing the deal anymore because they're leaning on someone else to do it. And I actually worked on a transaction last year where this happened. It was a single shingle lawyer, really nice guy, but he was actually not an M&A lawyer, to be honest. We're going through the process, and employment law situation comes up. There's an employee dispute in the closing process, and he has no knowledge of the Employment Law Act and really needed to loop in another firm to do that. All that did is create more cost, because now the lawyer that got looped in is charging maximum dollars, because they know that they're only going to be used for this little piece of the transaction. So the client is paying a premium for their time, because the lawyer knows, I may only charge 3-4 hours worth of work, but you're charging at 50% above market. So that just creates more cost for the client. And you could have been avoided if that client went to maybe a more mid-sized firm that had an employment lawyer in-house that could have handled that transaction. The other one is speed to close. So here's another transaction we closed last month. Really small deal. So actually, this is a perfect example. It was a small deal. It was $2 million. But they used Aird & Burles, a bigger firm as well. But the reality is, in that situation, they needed to close ASAP. It was a distressed opportunity. We needed to move really, really fast. The buyer was there, ready to close. And if we gave that file to a really small firm with a 1-2 partner type situation, they may not have been able to move that file as quickly as Aird & Burles did. And I'm not recommending Aird & Burles here, because, every situation is different, but they did a fabulous job. They moved literally from LOI to closing in 1 week. They threw about 10 bodies at it, cost a lot of money, but they were able to throw a ton of bodies at the file and move that file really quickly. So the bigger firms get the advantage when it comes to speed. If you really need to move faster in your distress situation, I would say the bigger firm is better than the smaller firm. But say, for example, it's a 90-day close or 120-day close. That's a standard closing period. Like, speed is not a differentiator there, and therefore, big or small, it's no different, right? But if you need the speed, I would say the bigger is the better. The other one is required handholding, and this is more of a soft issue, but it's a really important issue, especially for the types of businesses we're working with. So again, we're in that $2 to $50 million range. Most of the businesses are first-time business sellers, family-owned businesses, either first, second, or third generation. So these family business owners, they really want that right-hand lawyer, that person that they can lean on and call, and the availability of that lawyer that they can call them at 7 o'clock on an evening on Friday, and they'll be there. and they're talking to the senior partner on the file, the guy or girl that has 30 years worth of experience, and they can quickly, feel like, okay, you know what, I have access to you. The challenge with the bigger firms is that those partners, they're very capable. They're superstars. The challenge is that they're working on multiple files because these bigger firms, the whole goal is to scale and to serve more and more clients. So the ability to grab onto that senior partner's time and really hold on to them and feel like they're there all the time with you is less. So the amount of required handholding, if you really want that experience, then you should go with smaller versus bigger, because the bigger, usually they're going to send you down to the mid-level, either a manager or a junior partner to serve that file. Now, those are capable people. It's just that you may not feel that, oh, I'm not really getting that premium experience, that luxury experience. And it's no different for us. That's why we're a boutique M&A firm. I mean, you could work with a bigger firm, but you're going to get schlepped off to a junior guy that may not know as much as I do. So, you can deal with me directly and feel like you have access to me 24/7, but that means that you work with a smaller firm versus a bigger firm. Okay? So these are kind of the drivers that really influence whether you go big or small. Complexity, speed to close, required handholding, and size. And if you kind of ask yourself, where do you want to be? Do you want to be a little bit, if it's less complex and it's a smaller deal and you don't really care about handholding, well, then maybe you just pick a small firm or a mid-tier firm. So there's no right answer. At the end of the day, it's really budget. Because in general, I would say the big firms are always going to be more expensive. The mid-sized firms, kind of the 10 to 100 partners, may be 60 to 75% of the cost, whereas the small firms, they're the cheapest, but also you may not get the full depth of the experience of a bigger firm. Okay? So let's move on to common mistakes. So there's a couple. And usually I would say these all start with either cost and or trying to do something really quickly and just missing the boat on the bigger issue. So the first one is picking the cheapest. And I can't stress this enough. Like, the difference between the cheapest guy and a middle of the field, really capable M&A lawyer is not hundreds of thousands of dollars. It's not. It's tens of thousands of dollars in our market, in the SME, lower mid-market space. So I was working with another client, a year and a half ago, and she was very cost sensitive. And so I gave her 3 different firms, big, mid, small, and she obviously went with a small one, but she had a complex deal. And I asked, what was the difference between the small and the mid one? And she was like $7,000. And so I would have thought, like, the best one in my eyes, if I was in her shoes, knowing what I know, I would have picked the middle one. But that $7,000 really meant a lot to her. And the reality is, for a deal that she was selling that business for $8 million, the difference of $7,000 should not change who you pick. So be careful. Don't step over the dollar to pick up the nickel. It's one of my favorite expressions, because sometimes picking the cheapest is not the best. And they're probably, if they're cheapest, they're probably not busy, and they're not busy for a reason, because they're probably not the best lawyer. Okay? The other one is, as I mentioned, looping in the lawyer too late. So if you wake up and you sign an LOI and then you bring in the lawyer after the LOI is signed, well, they can't opine on that LOI and try to make any minor modifications because you've already locked into the LOI. Now, you can still make changes, but anytime you bring that up, now it creates this added layer of stress and an ask. It creates an ask. And from the buyer's point of view, for you as a seller, if you start nitpicking and changing the LOI, what they're doing is they're tallying it on in their mental mind. And they're thinking, okay, I just gave you one here, I gave you one here, I gave you one here. And the next time they want to ask for something, well, hold on a second, I just budged on these 3 issues. I expect you to budge on me for this issue that I'm asking for. So it's this kind of, why not bring them in earlier so that you can avoid those potential disputes later on in the process. Another one, I mentioned it obviously, is not having relevant M&A experience. A lot of lawyers, and the problem is, and this is the fault of the lawyers, is a lot of lawyers say they actually do M&A. Yeah, we do M&A. I'd say 10 to 20% of those people that say that they do M&A actually don't do M&A. They maybe do one M&A transaction a year. I'm working on one right now where, nice guy, smaller market, but he's not really a strong M&A lawyer. He does 1 or 2 deals a year. He's not really accessible. He's not quick, and he missed a couple of things. And it's just like, it just wasn't a smooth process and really created unnecessary stress in the closing process. But he said he did M&A for the reason of, why I want to work on these transactions, because they're profitable, they're sexy, they're cool, Everyone wants to work on M&A, but what you need to do as the client interviewing that person is you want to dig in and say, okay, you say you work on M&A. How many transactions do you do a year? If you say you would do one or two, you're not really an M&A lawyer. If you were working on 10, okay, you have experience. What type of industries are you working in? Like, dig in. What industries are you working in? What transaction size are you working on? What type of what type of client do you work with? Do you work with more the seller or more the buyer? You want to just understand their experience and really question them. Dig beyond the primary level of just asking them if they do M&A. Understand what type of M&A they do to really get a feel for that. Another mistake is the transaction size mismatch. And so this goes back down to when you're interviewing a lawyer, ask them what is the average size of the M&A transaction that they work on. If they say, yeah, well, we work on transactions anywhere from 2 to 500 million. Great, that's a non-answer. Be more specific. Last year, how many transactions you work on? Okay, 10? Perfect. Of those 10, just roughly what's the average of those 10? 70 million. Okay. Well, if you're a $5 million seller, should you be working with a $70 million M&A guy? Are you going to get the most amount of attention from that person? Are you going to get the A-class treatment? Or should you go down a little bit and work with someone that works with a similar size business? It's no different with M&A firms. If I have a client that reaches out to me, and I would never say yes to this, but say, for example, it's a $100 million business, and they're like, Robert, love your video. You're the finance kid. I want to sell with you. Okay, great. But I have a $100 million business. My capability, the depth of my team and my buyer network, my whole mindset is geared towards a different marketplace than what you're doing. And it's no different with M&A lawyers and the complexity of those transactions. Bigger transactions bring different issues than the smaller deals, and vice versa. We've seen a lot of situations where big capable law firms over lawyer small deals. They get involved with these small deals and they treat it like it's a big deal and create all this complexity for the other side of the table where it's like, whoa, you're bringing out the bazookas and let's just figure this out with our sticks and stones. So it's not safe to just pick a big firm. Sometimes a big firm actually can create more damage than the small firm. That the other common is ignoring team depth. So, from a business point of view, you want to understand the capacity of the lawyer that you're interviewing. And I would say this is more of an issue when the M&A markets are busy. So, in 2024, it's a little bit softer. But say, for example, it was peak just after COVID, 2022. M&A was ripping and roaring. Everyone was making money. Everyone was really, really busy. At that point in time, you're trying to find someone that, based on your situation, if you really want that hand-holding and you want to work with that person that you're sitting in front of, you need to make sure that they have the capacity to give you their time. And how much capacity do they have? How many deals do you work on a year? Okay, relative to the last couple of years, are you really busy or are you only are you kind of in the middle? Are you slower? How busy are you? And if you can ask those questions and really get a sense of busyness, that also gives you an opportunity to negotiate on price. Because the reality is, if the lawyer that you're talking to is not so busy, then there's maybe more flexibility on price. But if they're really busy, just recognize that you are probably the fifth knock on the door for that person, and there's probably less flexibility for you to negotiate on price because they're just busy. They're just going to move on and pick the next client that wants to work with them at the price that they've given them. So just be aware of the team depth and the capacity. The other one is skipping the referral stage. Countless times, people are in a hurry to get the deal. Either on the buyer side, they meet one person, they really like the person, there's a good chemistry fit, but they don't really ask for referrals. And it's no different. Like, even for us, I'd say half of the time clients come to us and they interview our firm, they never ask for referrals. And I think to myself, if I was selling my business, I'd ask for a referral. I'd ask for past clients that you've worked with that are like me in terms of size and or the type of person I am. So if you're a seller, ask that lawyer for other seller clients that have gone through the process with them. Pick up the phone and talk to those clients and ask them, how was the lawyer? Were they available to you? Were they responsive? What frustrations did you have throughout the process? Where were they really good? Where were they really, really weak? And those clients are going to be more than happy to talk to you and just open up to you because they've been through the process and they're like you. They were a business seller going through the process probably for the first time. So don't skip the referral stage. Ask for 3 referrals. Call on those people because you'll probably find out more about the quality of that lawyer from their clients than from the lawyer who's done a really good job at mastering the sales pitch. Okay. The other one is a wrong communication styles. I've seen this a couple times where, picking the right lawyer means assessing their communication style. And that also means, part of that is when you call on the referrals, really inquiring about how they handled past situations. Were they really aggressive and more of a litigator style, get the ball across the line, push issues really hard and kind of, draw blood from a stone? Or were they softer, more strategic, more psychological in their approach, and really kind of finding a balanced answer and middle of the fairway type negotiator? So, and what you need to do is understand, what do you need for your specific situation. If you're buying a business where you need to work with that seller for another 12, 18 months, and you hire a lawyer that's really aggressive, even though it's not you, the seller's going to think that that's an extension of you. And when that aggressive lawyer tries to negotiate with the seller's lawyer and the seller hears how aggressive your lawyer is, they're going to get the impression that you're aggressive, that, now I view you in a different light. So it's important that not only do you pick the right lawyer for you, but you pick the right lawyer for that seller and that situation. Now, say, for example, you're buying a business where it's distressed or you don't really need the seller after 30 days. Well, then this is less of a concern because you can be aggressive and there's not a lot of, you're not going to get penalized for it. But if you're working with a seller post deal and you really need to work with them and build a relationship, your lawyer can actually create pressure between you and the seller and your relationship. So be careful of picking the wrong of one. And then the last one is not actively managing cost creep. And so in the next slide, I'm going to talk about best practices around how to control costs. But the reality is most lawyers will not put a fee cap. They'll give you an approximate range. So when you ask them for, quote me this work, how much are you going to cost? They're going to give you X to Y, and based on the anticipated workload. What you need to do is you want to make sure that you get that in writing, but you also want to regularly manage and check in on your bill. So don't let one bill come at the end of the process. What you should do is, a month or two into that deal closing process, check in and say, hey, John Doe or whatever, can I get an update on the fees? Just give me a breakdown right now, and just keep the lawyer aware that you're keeping an eye on the till. Because I've seen this a couple times where, the buyer and or the seller are so focused on closing the deal, they don't realize that every single minute counts in terms of cost. And so they're really surprised at the end of the process where it's like, whoa, that's $120,000. I mean, where did the $120,000 go? Versus if you're checking in on a monthly basis, you can avoid situations where maybe you're leaning too much on the lawyer for certain situations. And you're like, oh, this is costing me. Let me change my approach throughout the closing process. So I'm not saying that you should be cheap. I'm just saying that you should be aware of your cost. And it's no different than taking a taxi. The more you ride in that taxi, the more expensive it's going to be. So just keep an eye on that meter so that you're not surprised at the end of the process. Okay? So one of the $1 million questions I get from a lot of different clients is, how much do M&A lawyers cost? And so before we actually talk about the numbers, let's actually look at how do lawyers think about cost. So in general, I would say most lawyers are going to price on an hourly rate, but they will ask you for what is the timeline to do the deal. So if it's really, really quick, there's going to be a premium associated with it because, again, you're asking them to dedicate a lot of their current capacity to that. Versus if it's a longer process, then maybe they can, manage their capacity and fill in their time and spread out your work, and therefore maybe there's less of a premium on price. So just expect that if you're trying to close in 30 days, there's probably a premium associated with that from the lawyer's point of view. The second one is the scope of work. So it goes back down to what the M&A lawyers do. Well, what are the documents in the closing process? Will there be a shareholder agreement, or is this 100% sale? Will there be a purchase and sale agreement for the real estate, or is there a lease in place with the third-party landlord, and therefore no legal document has to be drafted for a real estate lease? These are some of the documents that increase cost versus if it's a really simple deal, then less so. Then complexity. So in your situation, is there, again, a union agreement? Is there something unique that is required for your industry and or situation? Is there special regulatory requirements? Is there cross-border tax implications? The more complex, obviously, the higher the price, versus if it's a simple share deal, there's no real transfers. It's just a regular old distribution business, it's probably going to be less complex, and therefore the fee is going to be lower. And then the last one is specialization. So sometimes some lawyers may specialize in a sector like automotive, trucking, technology companies. And so what ends up happening is because they have such a strong niche and sector focus, they actually charge a premium for that because you get the associated additional knowledge of that lawyer being really capable in that space, probably being a more stronger in terms of a negotiator and getting that deal done. So I would say oftentimes if they're really specialized and you want to lean into that specialization for the safety of having a better equipped M&A lawyer, that's great, but just realize you're probably going to pay a premium for that as well. Okay, so just talking about fees now. So I kind of mentioned, and just addressing these points here. So in general, the buyer's lawyer is going to be more expensive than the seller's lawyer. The reason why is that the buyer's lawyer prepares the documents for the seller's lawyer to review. So I would say 10 to 30% less for the seller versus the buyer's lawyer's bill. Okay, for that same, assuming they were doing the same transaction and we're using a similar type of lawyer. It's just that there's more work involved for the buyer to initially prepare the documents, and then the lawyer, all they have to do is review and comment. Therefore, there's less hours involved in that for the seller's lawyers. Now, in terms of cost, the general rule of thumb, which is still, I would say, accurate in both Canada and the US, is that a lawyer should be between 1% to 2% of your deal value. So that's kind of the sweet spot. So if you're about $1 million transaction, I would say it's closer to 2% because usually the percentage is higher on the smaller transactions. If you're a $10 million deal, you're probably 1%, which comes out to be about $100,000. If you're a $1 million deal, maybe you're 20,000, 30,000, which is about 2%. So what we've done, and this is just based on our kind of view of the marketplace here in Canada, in Toronto, Canada, and these figures are based on Canadian dollars, by the way, is, I've looked at the last 30 transactions that we've done, the bills that our clients have received based on those transactions, and segmented them out on price. So this is not an official report, but this is just more our view of the marketplace and what we're seeing in Toronto. So for a price for a $2 million business, as I mentioned, 1% is the bottom end we've seen. We've seen as high as about 2.5%. At $5 million, you're about $30,000 to $80,000, and that's a big range. Again, it goes back down to complexity and really the type of transaction, whether it's an asset deal with a shareholder agreement or it's a share deal with no shareholder agreement. So that kind of ranges from 0.6% to about 1.6%. On a $10 million deal, most deals are going to land in that 60 to 100. For really super complex deals, maybe you'll go to 125, 150, and then 200,000 for closer to cross-border deals with a big private equity firm that just wants to make everything complicated. For a $20 million deal, definitely it's minimums at least 100,000. Sometimes you see those goes down to about 80,000 for that single shingle boutique law firm. But I would say 100,000 should be the minimum for a $20 million deal, and we've seen it go up to even 300,000 on more complex multinational type transactions. But as you can see, the low end floats around 1%, the high end floats around that 2.2, 2.5%. So, it's in line with the general rule of thumb, depending on the size of the transaction, the complexity of the transaction. But hopefully this gives you an accurate view of what we're seeing in the marketplace here in Toronto. Okay, so best practices. How do you actually manage costs? So now I'm not saying again, going back to the comment of don't be cheap. Obviously, this is a key partner that you want to invest in, but there's some best practices to make sure that, you don't wake up with a $200,000 bill when it should have been $100,000. The first one, and this is one that I recommend for just in general best practices in terms of making sure the deal closes, that the deal closing process is super smooth, is having a detailed LOI that addresses a lot of the key deal points. The more detailed your LOI is, the shorter the legal negotiation process is after the fact because you've addressed everything. So in our transactions, we usually have an 8 to 9 page document, very detailed, that addresses not only the price, but the security terms behind seller financing, the net working capital target, the non-compete agreement, the lease terms for any real estate that gets leased, the consulting terms and the term and the compensation of the agreement for the seller's consulting agreement. All of these things are included, and therefore there's less surprises later on in the process that require the lawyers to get involved and smooth those out. So that's a big one. The more detailed your LOI, the more you can negotiate up front without the lawyers involved. Obviously, the lower your legal costs are going to be. The second one, this is a really important one. It's tough because sometimes the issues are blurry between whether they're really legal or business issues, but try to really understand whenever you're looking at an issue in closing, is this a business issue or is this a legal issue? Oftentimes for first-time sellers, they over-rely on the M&A advisor. And I know a lot of M&A advisors that really lean into that. That's their strategy to get the highest possible fees on the deal, is that they'll take everything on. The advantage is for you, if you have an M&A advisor, your M&A advisor is not working on an hourly basis. And if they're competent, maybe there are certain issues that you actually triage and say, okay, these are legal issues. Obviously, the lawyer should look at these when it comes to specific sandbagging clauses or different types of reps and warranties and how we represent and warrant the information that we have. But there may be business issues around employee transition, it's employees signing on to contracts, the landlord negotiation, and the assumption of a real estate lease, whatever it is. And is the lawyer getting involved in that? Or can you as a seller do that yourself? Or should your investment banker, who's not working on an hourly rate, handle that? So for you as the client, it's important to sometimes separate and decide. You don't want to send everything to the lawyer. If you're going through the closing process and 10 issues come up and all 10 are addressed by the lawyer, you're going to have a big legal fee at the end of the day because they're on an hourly rate. But if you can separate some of that, maybe give 2 to your investment banker, 1 to yourself, and only give 7 to your M&A lawyer, you're keeping your costs in check. So that's a big one. And I oftentimes feel like, especially sellers that are going through the process for the first time, sometimes don't understand that you're actually giving direction to your lawyer. And sometimes there are issues that you should just handle yourself and then just give to the lawyer to paper. Don't over rely on them. Another one, and this is a bit of a cheat code, is geography. So say, for example, you're working with a firm like Miller Thompson, mid-sized firm. You can go and pick Miller Thompson's team, M&A team in Toronto, or you can pick Miller Thompson's team in Ottawa. Now, both are Miller Thompson trained. Both have been employed by Miller Thompson for maybe 10 years or whatever. But the overhead costs of operating in a larger metropolitan city like Toronto or New York just genuinely raises the rates for the same firm and the same type of service. So you usually see fees that are maybe 10, 20% higher in the bigger areas and the more populated areas versus regional territories where it's the same firm, it's just a regional office, and therefore their overhead costs are lower. So that's a little cheat code, and I'm definitely in Toronto. I know a lot of smart multi-business buyers that have a lawyer that's 2.5 hours out in London, Ontario, that is actually their go-to lawyer. That is half the price of an equivalent Toronto lawyer, simply because they operate out of London, and therefore their overhead costs, their labor costs, everything's lower, and therefore they don't need to charge as much. Sometimes the reason why these firms are so expensive is they have $1 million rental rate on their office in downtown Toronto. The last one is more of a communication tip, especially with your lawyers. Manage your email flow. I would say most people have gotten into the habit of just sending emails and constantly communicating on email, replying on emails. And I see a lot of deals where every email that crosses my desk, I just think, that's 15 minutes for that lawyer to read that email. It's another 15 minutes for them to reply. If they're at $1,000 an hour, that's half an hour. So $500 just to read your email and reply to your email. That creates cost. So sometimes what's really effective is to cut down on the back and forth, pick up the phone, call the lawyer. Pick up the phone, call the lawyer. Sometimes it's better to actually, just from an efficiency point of view, just to cut that off and reduce your email flow, because emails actually create more costs sometimes. Now, other times, obviously, if you're replying in the evening or you have a really long email and there's a list of things to do, email is better. But sometimes email is actually not good and creates more cost for you as a client. So manage your email flow. Okay, so that's really a summary of hopefully everything that you need to know when it comes to hiring an M&A lawyer, what their costs are, best practices, common mistakes, how to go about hiring one. If you have any questions or maybe you're looking for referrals in the Ontario marketplace, I am more than happy to put a couple names in front of you. Please reach out on LinkedIn or you comment below, and I'm more than happy to make those recommendations. As well, if you're a business buyer and you're thinking about buying a business, we have 1 hour consulting sessions that you can book online. Go to the Finance Kid website, and more than happy to get involved and actually be a deal consultant for you and just be a sounding board for you. And if there are any other questions or you just want to keep following the channel, I'd love and I'd really appreciate if you can like and subscribe to the channel and share this video with others. So thank you all for watching and have a wonderful day.